proceso arbitral actuado en materia de propiedad intelectual.
Arbitration process. Practical case. Ecuador. Consuelo Ejumea from Colombia. Cristian Mier from Chile. Carmen Paz Alvarez from Chile. Estuardo Jáuregui from Guatemala. Eduardo Lobos from Chile. Costa Rica. Mercado from Bolivia. Fabiola Sáenz from Costa Rica. Lilia Rosales, Argentina. Good day, everyone. To want to know, thank you for being here with us. And this is the Committee of Mediation and Arbitration. So thank you for being here. What we are going to cover today is a hypothetical case in order to show you or help us to understand how an arbitration process goes when it comes to intellectual property. So let me introduce you very quickly. Who do we have here? We have the rapporteur, this Consuelo Behumel, the maximum representative of and this is the representative of, and so we have the three arbitrators. We have Bernardita, Eduardo, Lobos, and the secretary is Paola Castro. We have the witnesses from the two parties, from the claiming party, and for the development of the logo he feels exploited, non-respected by the counterpart, Fabiola, and the representative and influencer, Cecilia Romolu, and Pepita, and the rest of the members are here just assistant or an accompaniment of the members of the courthouse. And this is part of a center, and it's very heated over here. It's heated because the air conditioners are not working. So we hear in the first in the members of the trial of the juries, and in this center on the other side we have the rapporteur. Each one of the sides, there are the two parties, the claimant, the defendant, and the people here in the audience. They're making comments, they're impatient, and there are the witnesses of both parties. So everyone is using fans or using a way to be not that hot because of the temperature. Let us all stand up for the entering of the members of the court. Good morning. Let me take a seat. Good morning to one and all. As the president of this arbitration court here in Panama, we now hereby start this hearing for the answering arbitration and the evidence. And this is about the product 6 Wonders from branding. Please, Madam Rapporteur, could you tell us who are the parties? Of course. The claimant is the corporation Six Wonders with the NIF number 1000763-3, formed in accordance with the Republic of Colombia by public document from April 1990, filed at the Chamber of Commerce of Bogota in 1990 under number 12345 of the ninth book, registered as a commercial entity. This corporation was formed by Mr. Sexcondo and Mrs. Maravilla in order to start working in the manufacturing of cleaning disinfectants for domestic use, aimed for the final consumer in order to sell it in the Andean community, Mexico, Costa Rica, Panama, Chile, Guatemala, and the copies of such documents are here in the file. The defendant party is a company called Branding SAS. Branding SAS is a well-known branding positioning company for marketing, advertisement, formed by as per the laws of Argentina, with headquarters in New York, Mexico, Madrid, and Bogota. The copy of the certificate of legal existence is in the file. Thank you very much, Madam Rapporteur. Now, I would like to ask from the Secretary for the appearing purposes. I would like to know if you may confirm if the different parties are well represented. Please be very specific and clear. The defendant, there is no power of attorney of the defendant party in the file. I'm very sorry, Madam Rapporteur, but we delivered the power of attorney immediately before the beginning of this hearing. So please verify that, because there are documents that are absolutely necessary for these purposes. Mr. Attorney, good morning. I would like to beg you that the documents must be delivered previous to the hearing, so in order to avoid delays. So please, we would like to ask you this not to happen again. I already verified it, Mr. President. For the purposes of appearance, please we would like to identify the different parties. Good morning, honorable members of the courthouse. This is Maximo Condor, legal representative and attorney in legal practice, representing the company Seis Maravillas, duly credited. We would like to have access to the power of attorney of the counterpart to verify it. I would like to request the same, to have access to the document of my colleague. As per the request, we have verified the mandate, so it is legally constituted. I would like to just point out to the attorneys that we're just starting this hearing, and we're not going to start any type of dilating allegations. I would just like to state that, because we would like to ask you to please be very quick in your presentations and statements. Madam Rapporteur, please very quickly just point out what are the facts of this cause, whatever doubt that you might have during this statement. Please let us know. The corporation Seis Maravillas has signed a contract for rebranding with the Renombrada Branding, another company legally represented by Marta Mendieta, for a value of $1 million. It is in the file a copy of the contract and the certificate of legal representation. It was presented an idea of branding, and first of all, to change the social title of the juridical person by the sign of plus and as an aseo SAS because this corporation was easier to be remembered by the consumers. Second, it was recommended to request the search of background and the registration of the trademark signal as aseo in the classes 3 and 5 in nominative form, informing the contracting party that the agency had already done a search of background, non-formal one, in the Andean community, Mexico, Costa Rica, Chile, Guatemala, Panama, and it was not found any prohibition. It was determined that the expression formed by the sign plus, the plus sign, and the word aseo or cleaning was a very strong phrase because it was very well remembered by the consumer. Having not found any background, and as per the request of the manager of the corporation, Seis Maravillas SAS, it was possible to launch the brand. The brand, the plus sign plus the word aseo, was relaunched by Astuto Benavides, linked by the company Renombrada Branding SAS through a contract for the provision of services, just like it was been done since 5 years prior. 5 years prior. So Mr. Astuto Benavides presented the company plus sign aseo, different type of presenting this brand plus sign plus aseo. And Mr. Maximo Kondo chose one design, a very sober one with any other without any other additional elements. After choosing this design, Astuto Benavides delivered the manual of the brand for the use of the different signs and the different products, business cards, stationery, uniforms, hats, and the use of the brands in communication and digital media, web page, social media, and the email account. Mr. Astuto Benavides was not linked to the advertisement company, and he felt like non in agreement with the condition he had with the brand company because his contract for the provision of services for him complied with all three elements, therefore leading to a labor contract. So the equipment, the team of the company Renombrada Branding hired a media company to do the launching of the brand in all the national and international mass media. And that is how the brand plus aseo was then broadcasted in Caracol, RCN, and in different TV and radio stations, CNN, and the most different media, the well-known ones of Bolivia, Ecuador, Guatemala, Chile, Peru. The media agency hired influencer, the most well known of the region, Ana Bontrat, to launch the campaign in the different aforementioned countries. Excelente Bontrato, with high school studies without any college degrees, signed companies and have signed companies as an influencer with the largest companies of the world, allowing her to get a high amount of money, therefore did not require as much information. Excelente Bontrato launched a comparative campaign of the different cleaning products of the new client without making a consultation to the client. Detergent for laundry, disinfecting soaps, ambience deodorants, and for cleaning the floors, and all identified with the sign plus sign and aseo from the same powerful Poderosa Inc. identified with the brand Poderosa, very noticeable brand, in order to identify these products in class 3 and 5. Excelente buen trato in her media campaign ensured, and I quote, "In my house, we have bought all the products under the brand Plus Aseo for cleaning and disinfection, and we have confirmed that these are 3 times more effective than the up to now the number one brand of the cleaning industry called Poderosa." The company Poderosa hired a people in the United States to do the test of the effectiveness of the different products with the label of Poderosa, and at the same time to confirm if these products offered under the brand plus sign aseo were as effective as Mrs. Bontrato said. The results of the labs showed that the advertised products were manufactured with very low quality raw materials and did not comply with what the influencer was saying, and didn't even match the quality of the products identified with the brand Poderosa. Even less, the products were 3 times more effective.
Also, the company Poderosa requested the advisor in regulatory matters to revise the information of the products that had the brand Más Aseo, who found that the sanitary registration were expired recently and they were not renovated. They had not been renewed. The new administrators of the company Seis Maravillas and the heirs of Mr. Condor, they considered that it was more competitive if they sold more economically, and that way they would have to buy materials that were in lower quality, and therefore when they changed the formulas that would require, they needed new sanitary registrations, and for that it was not necessary to renew the sanitary registrations. However, the employees of Más Aseo SAS, they forgot to inform the company that was in charge of making the packaging regarding this change of the sanitary registrations. The company Más Aseo paid the branding corporation $1 million to create the brand, to develop the publicity and the positioning of the brand. After 3 months of that campaign, of the launch of that campaign, and the positioning of the brand Más Aseo, Mr. Máximo Condor, he started to be notified of the following: administrative public action of the industry and commerce, unloyal practice by Poderosa SAS for deviation of the clientele. The freelance Astuto Benavides, he made a claim of violation of author for using that brand Más Aseo that was created by him and that was not a transfer of the rights. Unused presented by the company Más Aseo, made by 2 words, Más Aseo SAS, the company created in 1974, that means 50 years before, with a registration of the brand Más Aseo in the whole American continent and in the classes 3 and 5. The legal representative, the American citizen, Linda Carter. Mr. Máximo Condor, on all these claims, he requested the registration of the brand made up by the sign Más Aseo in the classes 3 and 5, and they found that there was registered already the brand with the expressions más aseo in the same class and for the by the company más aseosas in Mexico, Costa Rica, Panama, Ecuador, Peru, Bolivia, Chile, and Guatemala, and Colombia. Thank you very much, Ms. Rapporteur. Very complete. Thank you. I appreciate this, Ms. Rapporteur. We're going to be asking some questions directly. Please, can you say what is the request of this claim? Please be concrete with your answer. The company Más Aseos has presented an arbitration against Renombrada Branding to indemnify the damages for $1.5 million, from which $1 million correspond to the value that was paid for the defendant and 500,000 to cover the legal fees in the defense on all the claims that were received. Mr. Rapporteur, to the clear of the court, so what is being claimed is the uncompliance of the claim. So yes, it's non-compliance of a contract. Yes. Please, could you explain what are the obligations that you are calling to be non-compliant? I will be giving the microphone, the floor, to the lawyer of the plaintiff. So in 5 minutes, please, if you can be very concrete and do not go over that time, please, 5 minutes of the opposition of this case. Mr. Lawyer, go ahead.
Muchas gracias.
Thank you very much, Your Honors. Well, essentially, this is a contract in non-compliance of a contract against Renombrada Branding, since they contracted this company for the creation development of a brand in very absolute terms, with good faith, with a wide mandate to this company to do whatever necessary management or activities for these purposes. Therefore, Renombrada Branding suggested to change the name from Seis Maravillas to Más Aseo. In that sense, the client, trusting the trajectory, the reputation of success, previous campaign of the Renombrada Branding, accepted this change of branding name. Companies are very well known in the production of classes 3 and 5 products, and in good faith and in full trust accepted the change in the brand until the site was proposed by the Renombrada Branding expert in marketing the use of a creative person for the positioning of the brand and the use of different media for advertisement, whether influencers, TV, radio stations. Therefore, my representative acted in very good faith, considering that was hiring an expert in this matter. And they end up being sued by all these people who had difficulties with Renombrada Branding, and my client is not supposed to be sued by the action as per the actions or as a result of the actions of Renombrada Branding. Therefore, not only the $1 million for the services paid, but all the other the costs that were incurred by my client for legal representation to defend all the different actions that, due to the incompetence of Renombrada Branding, has been paid. Therefore, those are our claims. Thank you very much, Mr. Attorney, for your presentation. We would like you to please tell us what are the specific clauses of the contract which were infringed by the defendant. Please be brief. There are 2 specific clauses referring to the contracting of the services in order to state that Renombrada Branding was supposed to comply with. Another request by the court, we would like to know what are the actions that were developed by third parties against your client. They're all valid, they're still standing, and which have increased the legal fees and other aspects with regards to the patrimony, which ended because at the end the creative of the company came to an agreement with Renombrada branding, and so in that sense it is not longer legitimate to be able to undertake a legal action against my client. Very well. We now would like to hear from the attorney of the defending party. And in 5 minutes, please be very brief and tell us and explain your position. Thank you very much, Mr. Chair. Our position is mostly into sharing that all the different claims due to this recommendations, first of all, it's important to point out that there is a contract with the defendant, and in the first part it is stated that the brand must assume that there was an infringement of the brand. Please, we are not specialized in intellectual property. We are architects of branding and marketing, and we pointed out to the client that they needed to make a study in different jurisdictions to determine if the brand Mas Acel was able to be registered. Even though it was very strong commercially speaking, it could be weak when it comes to the registration of a trademark. However, Mr. Condor told us that he had no money to do this search of background and that he just made a quick search in the different chambers of commerce of different countries. Our in-house worker, he was actually very annoying with our client, Maximo Condor, telling him that he needed to make this search. So he told us that he had no money and that he trusted the search in the different chamber of commerce that he already had done. The contract that we have with Mr. Condor, he sued the company due to patrimony rights, but all of those legal suits already been withdrawn, and we have come to an agreement with Mr. Condor, and he had received a compensation for whatever damages. And with regards to Excelencia Contrato, we signed a contract with her through a mandate as per of her representation. And as per this mandate, the not our company as an advertisement firm was not to be sued, but the claiming party. Thank you very much, Madam Attorney. I would like to ask you something. What about the action of infringement that this action in which you said that you already have come to an agreement, was this made against our company and Six Maravillas? We have come to an agreement that conciliation was total, complete. Okay. Do we have any other questions? Thank you very much, attorney. With regard to the services that your company renders, we understand that it is of branding and forming of trade or brands. Do you do any studies about the messages that are going to be delivered? We do a complete review of all the messages that are going to be delivered, and it is also confirmed with our client. We have some doubts over here, Mrs. Attorney, because you said that the contract with Excelente Contrato was hired, but on behalf of the company Seis Maravilla, SAS, with regards to the brand Mas Aseo. Is there any contract for you to act on their behalf? Who executed it? Well, it was Mr. Maximo Condor. Thank you very much. You may take a seat. And now we're going to continue to review the first evidence provided by the parties, which is part of the file previous to prior to this hearing, would you understand, Madam Secretary, that there are no objections with regards to the practice of such evidence? Absolutely. The parties provided all the documents, the list of witnesses that you have in the file. Thank you very much. Let us continue with the review of the claiming party evidence. Thank you very much, Mr. Chair. We have attached the following background documents: a contract signed by my representative and branding, and it was determined that they had full, complete power to do everything about the branding. My representative invoices, which is related to the amount spent, and then 25% paid at the beginning, and then another 25% payable by the end of the campaign. And the contract that my client has signed with the attorneys for them to be represented due to different legal actions that they're facing. The contract of Renombrada Branding with the proposal, as I said, this proposal started by Renombrada Branding with regards to branding to the brand Seis Maravillas, which was changed into Plus Aseo or Más Aseo. And a copy of the claim that was filed by Astuto Benavides for the infringement of author patrimony rights, and a copy of unlawful competence lawsuit, and another copy of the lawsuit against my representative, and also the document in which Astuto Benavides terminates the lawsuit against the company Renombrada Branding, in which it is stated, and this is very important, they acknowledged that there was a labor relation with Astuto Benavides, and therefore they were able to come to an agreement in that sense. Thank you very much, Mr. Attorney. We are now going to verify the different evidences of the defendants. Absolutely. Thank you very much, Mr. Chair. We have, after the search of background that was made in the different chambers of commerce, as I already mentioned in my original allegation, the client considered that it was the minimum that could be done, and he didn't want to spend more money about that. Copies of the different messages in which the client said that it was not necessary to do anything more. Copy of a WhatsApp text sent by Pepita Redondo, a withdrawal of the lawsuit filed by Astuto Benavides. Copy of a document in which it is highlighted clause 35. Copy of the contract signed by with Excelente Contrato on behalf of the defendants. 469 pages of information that was found in Google with regards to advertisement and favorable messages of the product developed by Seis Maravillas SAS, which were baseline for the campaign of the influencer with regards with the products with the new name and the new image. As it was pointed out, these products, their quality lowered, and it was not to the knowledge of my representative client. Thank you very much. After you have listed the evidences which are in the file, it has not been objected, and there are no remarks in that regards. Therefore, those will be considered in order to solve this case. And now, we are going to start with the witnesses' testimonies. So please, Mr. Secretary, bring the different witnesses for there to be under oath. Gentlemen, please, we are now going to declare you under oath. Well, I'm an atheist. Well, but can you at least swear? Okay. Do you, sir, promise to tell the truth with regards to the topics that you're going to be questioned about? Very well. Thank you very much. You could leave. Who should we stay with? Thank you very much, Mr. Sure. We would like to call to the bench Mr. Astuto Benavides. Please take a seat, Mr. Benavides. Good morning, Mr. Benavides. The attorney of the defendant will be able to question aspects in order to verify that you are impartial. It is important for you to know that these questions coming from the defendant party are aiming to know if you are able to declare in this trial, regardless that there might be other objections. This trial will also receive your declaration and information, and at the end, we will determine the value of your testimony. Thank you very much. Duly noted. Thank you very much, Mr. Chair. I have the following questions for you, Mr. Astuto Benavides. Tell us if you have any direct or indirect interest in this matter. No, not at all. Do you have any connection, a friendship connection, relationship with the claimant party? I have no further questions. Thank you very much. Thank you very much, Mr. Benavides. Remember that you're under oath, and false testimony is considered perjury, so please just keep that in mind. I would like to ask you, tell us, were you a creative worker for this company for more than 5 years to develop and create global campaigns or specific announcement of branding and corporative images for this company? Good morning, Mr. Condor. First of all, what I would like to say is that finally I can see you. I can now put a face to such a creative product that I prepared for your company. What I can tell you is that yes, as a matter of fact, I work for the company Renombrada Branding in the development position and the creation of all this image of the brand Más Aseo. Well, thank you very much to witness. We would like to ask you if you, for a fact, gave the manual to about the use of the image of Masaseo for uniforms, hats, stationery, papers, and the website, email, etc. Yes, it's correct. I did a very important creative work for the brand Masaseo, and it called my attention that you chose the sober design. I don't know, the one that didn't use many colors, and that you were not interested in a more flashy image. But well, I prepared it as per what you chose, all the material for the dissemination and for the use of the image in paper, business cards, and for the use in digital and traditional media, so that the brand was a commercial success. Thank you very much, Mr. Benavides. Did you know the executives of Seis Maravillas, now Masaseo, before? No, I didn't. Please let us know if you what is your commercial relation with this company of branding. Yes, Renombrada Branding. Yes, of course, for more than 5 years. I have. In the case of the development of Masaseo, were you paid for your services and how much? Well, Renombrada Branding paid an amount that I don't feel it's important to reveal right now. Well, remember that this witness is under oath, and it's important for you to answer the truth. Well, I'm very sorry. I don't know what's the relevance of telling the amount that I was paid for. As a matter of fact, we went through a whole claim. We were able to come to an agreement. I see no point, Mr. Attorney. Regardless of you reframing the question, it is important for the court to know the amount. So please, the witness, you have to answer the question. Well, I have to then say that my fees for the creation and everything, but for the positioning of the brand Masaseo went to up to $70,000. So, were you involved in a litigation with the company rebranding? Yes. What was the purpose? What was the reason for this claim? Well, the object of this litigation was that I had a commercial services contract at first with many clients, but throughout the time, throughout 5 years of permanent subsequent contracts for different companies, I considered that the remuneration that I was getting from the company was not enough, and throughout that time, there were many other elements that came together to consider my relation with the company to be a labor relation, and that at the end of such relation I was entitled to all the different fees and compensations in that regard. So that was the reason why I had this claim with Renombrada branding, and that is why I felt that I needed to file claims against certain clients of Renombrada branding in order for me to compensate the imbalance with regards to my fees and after my work. Okay, so tell us, did you end that legal claim? Absolutely, especially the one that was presented against your company, Mr. Condor, was withdrawn because the company and myself, we reached a transactional agreement and we ended all of our controversies. And that agreement, was it acknowledged by Renovada Brandon that you were under a labor relation? Yes. Thank you very much. I have no further questions for this witness. Thank you very much. Now, your do you have any counter questioning? Absolutely. I would like to know if you have withdrawn in full this claim against this company. Absolutely. All litigations against your client or the number of branding is being withdrawn, and this is a full agreement. Absolutely, yes. No further questions. Mr. Benavides, thank you very much for your intervention in this proceedings. So you may leave the chair. Next witness, Linda Carter. We would like to call Mrs. Linda Carter. Thank you very much. You are going to be questioned in order to determine if there is some sort of obstacle for your testimony. Please, Mr. Carpet, tell us if you are friend or enemy of the defendant. No, no relation of that sort. You have any friendship with the defendants? No, we have no further questions. Thank you very much. Did you understand what was asked to you? Okay. Well, you may go ahead with the questioning. Well, thank you very much, Mr. Carpet. You represent the company Mas Aseo. Perfect. Did you sign a lawsuit against my company, Seis Maravillas? Absolutely, yes. In which countries did you file this lawsuit? Was it for misuse of a brand? Absolutely. We had the brand Masaseo. We're using it in whole Latin America in classes 3 and 5, and we have had a lot of problems. That is why I filed this lawsuit, and that is why I'm here. Do you know if my representative say Maravillas and now Masaseo requested the registration of the brand Masaseo in classes 3 and 5? Well, I don't know, but they're using the name and it is causing me a problem. Do you know if there is any intention or request from my client in that regard? I have no idea. How it harmed you? Well, the customers are confused. My brand was previously registered, and now this new brand is out there, and the consumers get confused, and they think it's the same people, the same thing, and it's a huge problem for my company. And they're doing this without the proper trademark registry. Thank you very much. No further questions. Thank you very much. Are there any cross-examination questions? Thank you very much, Mr. Carpet. Please answer the following questions. In your companies, do you make any prior search before you release your brands? Well, we have the lawyers in charge of that. I'm not really familiar with the whole process. What are the problems that the use of the brand Masaseo have caused to your Masaseo products? Well, as I said, my clients, my consumers are confused because they're too similar. So that's a problem. We have had losses of income. These products are aiming the same target market. Well, yes, they're the same type of products. Thank you very much. No further questions. Thank you very much. Thank you very much, Mr. Carpet, for your intervention. You're released. And now, Mr. Attorney, who is the next witness? I would like to ask Excelente Contrato, a renowned influencer. Should I sit here? Please take a seat. Mrs. Montrato. Please have some respect. Please, you have to sit down properly. I'm sorry. It's too hot in here. Mrs. Montrato, please, you have to be respectful to the court. So, please, I would like to ask you to please behave properly and in accordance to the seriousness of this event. Thank you very much, Mrs. Montrato. Well, Miss, I guess. Who do you work for? Oh, for myself. Oh, please explain. I'm an influencer. I'm famous. I'm on my own. I'm my own boss. So the company, Renombrada Branding. So did they pay you for as an influencer for this brand Masaseo? I guess, but I don't know. I'm not sure. I have so many clients. I don't remember. Do you still work for Renombrada Branding? Yeah, like they have asked me to work for some brands, but I don't know. It depends. Please try to be precise and please be respectful. Well, okay, yes. Thank you. Please, gentlemen of the court, you have heard that the witness had stated that she has received money from the Renombrada Branding. Therefore, I would like to object the witness. Therefore, there is a clear interest because, as per her own declaration, her testimony could affect the decision of this court. Thank you very much. Please be quiet. Absolutely. We would like to hear the response. Please we would like to not consider this objection because the contract that was signed with Mr. Contrato was a mandate of representation. Therefore, the this is the defending. This is the claiming party was the one who actually hired this witness. As we stated at the beginning of the hearing, we are going to wait. We are not going to consider the objection. Therefore, you may cross-examine the witness. We would like to ask you, Mrs. Bontrato. Did you know that the products had good reputations? I don't know. I was told to just to put these products out there. Did you put some messages in TikTok? Yeah, well, what I do is I Google information and I make some stories. Have you tested? No, never. I never do that. Thank you very much. No further questions. Any cross examination? Yeah, just one question, Mrs. Bontrato. Do you copy it all or you create something? Oh, sometimes I do, sometimes I don't. Be more precise. Listen, I'm so famous. I just create. The universe comes to me, and that's how things go out. Through technological media? Yes, thank you very much. Thank you very much, Mrs. Bontrato. You are released. Madam Secretary, please call the last witness, next witness. Hello, Mrs. Redondo. Take a seat. We are going to call. We're going to question you for some specific aspects in order for us to continue. Who do you work for? I work for the Umbrella Branding. Do you do this under a labor contract? Absolutely. I'm an attorney. During the activities of your company, what level of influence do you have for in decision making? I have direct contact with my client. I let them know all the information that is going to be provided for them, and I always ask for written approval. In the case of the Umbrella Branding, did you approve the contract between the Umbrella Branding and my client? Well, it was sent to you. You accepted it, and that is why it was executed. Who wrote it? Who drafted it? The legal team of Renombrada Branding. Thank you very much. I would like to object the witness because it is absolutely dependent of the party receiving payment and is also the responsible one for drafting the contract, which is actually the object of this claim. Absolutely, we would like to hear from the defendants. Please, we would like to for you to not consider this objection because this is our in-house attorney, and it is so relevant to hear all the information that she's got with regards to this. Thank you very much. You can continue with the interrogation. Thank you very much. Pepita Redondo, we would like you to answer the following questions. Did you send a WhatsApp to Maximo Condor referring to different law firms related in this market? Absolutely. First of all, we recommended to them that they needed to make the correspondence search, telling them that the searches developed did not include the registration of the trademark, and it was and we also told them that this was a weak trademark, and we explained to them that there was a huge difference between advertisement and trademark registration. We told them that we were not experts in that sense in trademark registration, and that they needed to look for a specialist attorney in different countries, and actually we gave them a list of recommended the best well-known attorneys, specialists in that area. We gave them contact information of all these colleagues, and as a matter of fact, they decided that with the search that they did was enough. So when we received that email, me personally, I sent him up to 3 WhatsApp messages to Mr. Condor telling them that there were risks and the economic consequences that it could lead to. He told me that it was okay, that he was okay with what he had, that he didn't want this sign. Maybe with a specific design, it would have been better for the brand, but still, in spite of our recommendation, he insisted, so we continued moving forward. I have another question for you. What is the difference between the search of the trademark registration and Chamber of Commerce? Well, Chamber of Commerce, you can search for a company name if there is an exact equal company name. So it's a huge difference. So, for example, in Argentina, in Buenos Aires, there is a commerce registration, and each province has its own commercial registry, so there could be differences in the different provinces, and in many places there could be that could happen the same in other countries and not in others, and it is absolutely different from searching the registry of trademark that must be under that must be done in the different registration offices. The contract with Excelente Contrato de Influencer, which is made based of a representation and mandate, absolutely, we told Mr. Maximo Condor who were we going to hire, the features, her curriculum, and he, actually we had 2 or 3 options, and Maximo Condor was the one who chose Excelenta the Influencer because he liked her profile and what she did. Thank you very much. I have no further questions. Thank you very much. Cross-examination, Mr. Attorney. Thank you very much. Madam Pepita, one question. The contract is signed with Renombrada branding. Is the usual ones that you sign with all the clients? With the influencer, I mean, your contract with my representative, with my client. Formally, the majority of our products have certain similar features. However, we provide a direct and specific service to our clients, so we do not reuse contracts. So the contract signed with you was very specific based on the long trajectory of knowledge that we had about you. So in general, your contracts, you consider to have a mandate to be able to contract other services? Yes, but you always require the approval of the client. Do you always get the approval of the client? Absolutely. I would like to once again remind you that you are under oath and perjury is please, we would like to make it quick. You're taking longer than expected. So, is it true that Mr. Benavides sued you in the company, and that after a conciliation agreement, you did determine that that you had a labor relation with them? We came to an agreement. We acknowledge that throughout the time the trajectory of the contract had modified. So there was a labor relation at the end? Yes. Thank you very much. Thanks to the witness. We understand that this is the end of the evidence practice unless there is a very specific request from many of the parties. No, not right now, Your Honor. So now we will take 1 minute. 1 minute, very specific, for your closing allegations, your closing remarks. Let's go ahead. Thank you, Mr. Chair and members of this court. I just want to confirm that out of the evidence provided and what the witnesses have confirmed, it has been confirmed what I have stated in the opening remarks. My client hired, based on good faith and legitimate trust, one of the companies of branding that was supposedly one of the most important ones, and in that sense, absolutely, she gave them a wide contract for the creation of a new brand development positioning in the market. So much that it wasn't Roberta Brandon who hired the services of the creative party, the media, and the influencer. And in that sense, my client acted in absolute good faith, considering that everything that Roberta Brandon was going to do was going to be adequately executed. And in the same token, it is now uh, difficult for us to understand that my client is facing four different legal actions, including the one filed by Astuto Benavides, in order to determine that there is a responsibility with regards to the actions developed by Renombrada Branding. Therefore, we would like for the contract and the $1 million be reimbursed, and to also reimburse all the legal expenses that have been incurred as well. Thank you very much. Now, 1 minute for your closing remarks. Thank you very much, Mr. Chair. I'm going to be very specific with regards to all the background that has been presented by the files and the witnesses. We have three aspects to highlight. First of all, my client requested thoroughly the claiming party to make a search in trademark. Had they done this, we would not be here. They didn't want to do it because they said that it was too expensive, and also it was sent to them a WhatsApp saying that they needed to look for a trademark registration search, and they didn't want to do it. With regards to Benavides, the legal actions were withdrawn, and with regards to Excelente Contrato, the influencer, it was hired as per a judicial mandate. Therefore, the lawsuit should not be presented against our party, but against the claiming party. Therefore, we would like to ask for you to not consider the filed request petition by the claiming party. This court, before these hearings, there were possibilities for reconciliation. Right now, we consider that we would like to ask you once again if there's a possibility of reconciliation or agreement. I know that it was already mentioned and stated. However, we would like to make sure if there's a possibility for this to happen, and obviously this would entitle for you to be able to not consider certain aspects. Effectively, there might be a possibility, but we would, in that sense, ask for the reimbursement of $1 million and also to review then other claims. We are willing to some sort of conciliation and to be able to negotiate certain amounts. We do not consider that this is a fair baseline for conciliation. Therefore, we do not consider this as possible. Thank you very much. We'll keep that in mind. Therefore, in accordance to what is in the file, we are not going to deliberate. We're going to take a few minutes to be able to render our ruling, regardless of the fact that at the end, the text of the ruling will be up for the parties for whatever appealings necessary or that you may deem advisable.
Y no es broma. Se ponen de pie, por favor, para recibir a los miembros.
Please stand up to receive the members of the court. You may take a seat. Thank you very much, Madam Secretary. This court has deliberated and we have adopted a final decision. The arbitration in charge will read the relevant part. Thank you very much, Mr. Chair. As an arbitration court, we have taken into consideration all the background of the case and given all the evidence presented and the documents now objected and the testimonies. With regards to the objections, we would like to object them in full. Therefore, it was not verified a direct monetary interest from the witnesses. Therefore, their testimonies are going to be considered for our final decision. Enter into the bottom of this case, and as per the different principles of equity, we as a court have determined. As Mr. Chair already said, you will be able to read the ruling in full in 3 days for whatever actions you may deem advisable. And so it is resolved that in all cases, the company, it's been confirmed that the company Renombrada Branding is a company that is not dedicated to juridical advisory. That given the fact that the company and Seis Maravillas, it was informed that they needed to make an official search of the sign, and that Seis Maravilla hired Renombrada Branding due to their expertise, and that this last company was supposed to do this action in full, which also included the verification of the advertisement messages that were to be released, especially that Mrs. Contrato provided information to this company. Given the fact that third affected parties are enabled to exercise legal actions without any indemnity obligation from the actor with regards to the defendant, we now confirm and resolve. We deny the compensation with regards to legal expenses, with regards to the claiming party, and to also approve the legal claim in part, considering that the defendant did not operate in good faith after not verifying the information of advertisement, rejecting the fact that the non-search of the information was because it was also mentioned that the search needed to be developed. Therefore, the payment amount to be payable to the claimant is of $500,000. Thank you very much. We then can leave the room. Thank you.